Jesus, I don't know. So, anyway, I wrote it in the file. So we'll take the rest. But did you find out the answer?
I did.
Okay. Showcase. Haverhill on Clark versus Woods.
Good morning, Your Honor. I dive before the plaintiff and my client is. Good morning, Your Honor. Tish Lee on behalf of Ms. Woods, and I believe Ms. Smith has an identical motion up. Are you planning to hear?
Why you gracing us with your presence?
Oh, because I miss you, Your Honor.
Is that what it is?
I just, it's been so long, and
Yes.
you know, YouTube is not the same as seeing you in person.
Yeah, I have to go places just to show people I exist outside of YouTube. All right. So I will also call the case of Haverhill on Clark versus.
Thank you, Your Honor. And both Ms. Woods and Ms. Smith are present. Well.
Okay.
Yeah.
All right. Go ahead.
So, Your Honor, this is our motion for summary disposition based on the short notice under the CARES Act. I know that the two of us have gone back and forth about this for a long, long time, Your Honor. You know my arguments and my position, but if you want me to spell them out, I can. But for the record, we did file our motion for summary disposition based on the fact that the demand for possession in both of these cases was only 7 days. And we believe the CARES Act requires that those notices, and because the notices were inadequate, that both of these matters should be dismissed for lack of jurisdiction under the Park Forest Doctrine, Park Forest at Blackman versus Smith. And so we filed that motion, and in response, plaintiff has argued that the CARES Act was essentially repealed by a HUD notice of interim final rule. And in our response, we argue essentially three things, three things: that the interim final rule was essentially revoked by HUD 2 weeks later, that it doesn't apply to the plaintiff's property because plaintiff's property is a low-income housing tax credit property governed by IRS Treasury rules and not HUD. And third, that essentially constitutionally you cannot repeal an act of Congress via administrative action by HUD.
Okay. I'm not even going to deal with that last one. This is
All right.
the world, but I get what you're saying. But
All right.
Okay. All right. Silence.
Yes. Your Honor, as the court knows, that both of these cases were filed as non-payment of rent cases. Essentially, the argument is a due process notice issue. Notice is the purpose of notice is to well inform the defendant or the other party of the claims and allegations against them, so that they can properly defend themselves or they can be afforded an opportunity to be heard in court. And we're now months in of these two cases. Multiple hearings have been had. Dispositive motions have been filed. Responses. Defendants have availed themselves of the court's jurisdiction to the right to counsel. And the CARES Act essentially, respectfully, Judge, is a tactic. It's just a tactic. It's a stall tactic. It's used to delay the inevitable. This argument is not based on the merits of these cases. Not one conversation has been had regarding the merits of the cases. What is the defendant? Are the defendants able to pay? Are they seeking resources? Are they challenging the arrears? I don't know this because I haven't had any conversation regarding the merits of the case. Is this effective counsel or the effective use of this court's resources? I do not believe so, Your Honor, because at the end of the day, it is still to brush this under the rug, to dismiss it, would be contrary to judicial economy and what's in the best interest of both parties. It would be detrimental to the defendant. It would also be prejudicial to my client to delay this any further. We are here. The defendant have just recently asked me for, sister counsel just recently asked me for ledgers. So now we're getting on the merits of the case. So instead of understanding what the status is regarding the arrears, we're now still fighting over this due process issue, this CARES Act issue. And I mean, people have tenants have subsidies for a reason. They have it. I believe that they need it. And it is essential to preserve these subsidies, high-tech properties, Your Honor. And part of effective counsel is to help them preserve these relationships and these subsidies.
Also, when we were here the last time, if you recall, one of the things I said is that you may want to file a new notice.
We did do that, Your Honor.
Okay.
So, I mean, I think both are.
When does that, if it's a 30-day, when is that set to expire?
Actually, I believe it's already expired. And so instead of my take on this, Judge, is even if a case was dismissed, it's still
you're going to refile immediately with a new notice.
Say that again?
If these cases are dismissed, you're going to refile with a new notice.
Right, but my issue here, Your Honor, is it would be detrimental to the defendant. If preservation of these subsidies or these properties or this tenancy is crucial. Multiple filings, even if it results in a dismissal, still works against them. It shows that a case was filed against them in summary proceedings. Yes, it was dismissed, but then another case was filed. Instead of utilizing this time to maybe
but how does
by way of a CD?
How does that? Okay. I'm not sure how that is detrimental necessarily to.
Well, because they could potentially risk losing their tenancy status, and sometimes, this is lifetime property. If it's lifetime, I believe that if they disqualify, I'm not sure if it's indefinite, but the risk of losing it alone is detrimental to the defendant. So I just don't understand why this is the route that counsel has decided to take on this when I would like to know, are there challenges to these arrears? Are they planning on paying? Are there resources being sought? Do they have financial assistance? I mean, these are important pieces of information that is crucial in resolving this case. You can't just brush it under the rug. And then what happens outside of court, Judge? They have a fiduciary relationship, landlord-tenant relationship that still exists. And are they going to offer their assistance to the defendants outside of court as well to resolve their arrears?
Well, I don't know that. What do you have to say to that, Ms. Lee?
Look, Your Honor, we are the defendant's lawyers. We're acting in their interests. And we believe, essentially, the notice requirement is not just about a notice, it's about opportunity to cure. And so to have 30 days to pay instead of 7 days to avoid having a case filed against you is...
Right, but here's what the problem is right now. I disagree vehemently with your assessment of the jurisdiction of this court. You know that.
Yes, I know that, Your Honor.
And I disagree with Judge Kunke's ruling, which is not binding on me.
Yes, we understand that, Your Honor.
Because I don't think it confers that's not how jurisdiction is conferred in this court. And the approach is, frankly, from my standpoint, jurisdiction has probably been conveyed. The question is have you asserted, in essence, an affirmative defense that would lead the court to determine that plaintiff's case that is fatal to plaintiff's case?
Yes.
That's the way I look at it.
Yeah, we believe so, yeah.
And I get you guys disagree, but it doesn't matter. I'm a judge. So,
To ask the court to exercise its discretion and authority, jurisdiction authority, Your Honor, in determining what's in the best interest of judicial economy and fairness and what would be detrimental to the defendant and prejudicial to the plaintiff.
well, but here's the thing. There's an interesting thing with affirmative defenses. They've asserted it. I've got a rule on that affirmative defense. That, I think, is where it then goes to, is there a way to salvage this without much else going on? And I don't know if defendants are interested in that at all.
Your Honor, we are interested in that.
So let me ask this, because my belief is that the jurisdiction of the court has been done. And I'm not ruling on the affirmative defense as asserted as of yet. How much is owing on Woods?
What's currently owes through August, $4,188 in rent, $170 in the attorney fees and costs. That's just, we haven't asked for additional costs, Your Honor. And then $4,358 is the redemptive amount. The last payment,
4,300 what?
the last payment that we received on her behalf was on June 9th in 2026.
Okay. And on, hang on, please. And on Smith, how much is plaintiff claim is?
Yes, Judge, I'm showing rent to retain in the amount of $6,915 due knowing through August, 170 attorney fees and costs for a total of $7,085. Last payment received was on 7/1/2026. And I believe there was escrow, but I'm not sure if one has paid to escrow and the other has paid directly to my client.
I have in Miss. How come I do? So in Miss Smith's case, I have no escrow. And in Miss Wood's case, I have 1568 in escrow. Yes.
I just wanted to mention on behalf of Ms. Smith and Ms. Woods. For Ms. Woods, she paid escrow, I believe, for July and August to the court. And also,
When did she do that? Hang on. Yes, she did. So I have another 1568. Is that what you have?
yes, sir, you have 3136.
Thank you.
And Ms. Woods disputes the balance because they failed to credit her one of her money orders, and she has proof of that. And for Ms. Smith, she paid her July escrow directly to the landlord. She did, which we discussed.
We discussed that the last. I get it. But the balance you gave me is with that credit.
Yes, it is.
So,
Again, no discussions about the merits of the case. If she offered or anyone offered.
look, stop. Everybody just stop. Everybody just stop. All I want to know is this. So, because here's just the practical reality. If I let them assert the affirmative defense, consider it fatal to the plaintiff's case, what ends up happening is the cases are dismissed. Then they're refiled, which seems to me is going to tack more court costs onto the defendant potentially at some point. So,
Your Honor.
folks, are you, real quick, Miss Smith or Miss Woods is what, about 1,000 some odd off from getting everything corrected?
Incorrect, though.
What is incorrect?
Balance that's remaining after you deduct the escrow payments is an amount that is incorrect because they failed to credit her a $500 money order. And then
Okay, So let's say, okay, what I'm getting at is this. Let's say the money order is there. Let's say somehow you got to litigate that. What my point is, Ms. Wood's tenancy can be preserved. It is so close to whatever. But I don't know whether or not you have an interest in that happening.
Your Honor, we do have an interest in that happening. They're our clients. And so what we propose is that this case be dismissed, that no court costs be assessed because it never should have been filed in the first place. And that
But you're not going to win that, because I would be dismissing not on the basis that you view the CARES Act. You might be right if they never invoked the jurisdiction of this court. I do not believe that to be true. So.
And so you'd be dismissing on what grounds, Your Honor?
That you've asserted affirmative defense that's fatal to the plaintiff's case.
All right. And
How?
so just focusing on Ms. Wood's case for now, Your Honor,
Yeah.
it's easily resolvable.
How
And
much?
we can resolve it before
500?
a case is filed, a new case is filed.
Well, maybe.
No, still.
If it's 500, so it's 500, that's at issue? Really? I mean, is that what we have?
Roughly around plus addition of tons of late fees and so forth resulting from that failure. We've been having a lot of ledger problems at Haverhill. I think they're trying to correct their books. They've been moving around a lot of rents paid through to a security deposit ledger inappropriately. So this has been causing a lot of confusion for Ms. Woods as well as for many other tenants.
Your Honor, I mean, that categorization, we're here for Ms. Wood's case. I don't appreciate her bringing up all the other cases. This is just, I mean, come on, we're talking about two cases here. Let's stick to the two cases. We haven't even had a conference.
Silly.
Honor, I mean.
No, you were even being silly. I'm just trying to figure out how much Ms. Woods, I would imagine, wants to have her balance the ledger sat and go on living her life. I don't think she wants to be here, although I'm a pleasant person to be around. She doesn't want to come here and see me. Right, Ms. Woods? You all right? All right. Somebody just tell me, why hasn't the issue regarding the money order been communicated?
Because their only interest was in a dismissal, Judge.
Pardon?
Because their only interest was in a dismissal, Judge. Again, there's nothing based.
You don't need you just don't need the sniping at this point. Where is the money order? You said she had proof of a money order
So with
her right now?
and she has attempted to address it with landlord and they won't even give her a ledger. This is very common with many tenants that are at.
Well, I don't know about other tenants. I'm just dealing with Miss Woods right now.
She's requested a ledger and has not received one.
Allegedly.
Okay, allegedly. Give me all right. Here. This is killing me, Smalls.
I mean, Judge, we're pretty reasonable here. If we were presented with if we were presented
Nobody's
with the order, we would have applied.
I just want this. All right, look.
I mean, our goals always.
Where's her? Are those her money order stubs? All right.
Would you like me to?
Yeah. Well, Anne, can we get?
I see them yet.
I know. Give those to Anne and make copies so that everybody has copies. If you're going to object to them, I will give you an opportunity to object to them. Right? Just, I will. So Ann, who can give me a copy of the ledger?
We have a copy in our possession, Your Honor. I can provide you.
Okay, Ann, get that too. Make a copy because I can't do anything with that. Please, thank you. All right. In Miss Smith's case, okay, I have a question in Miss Smith's case. When we were here July 30th, and I'm now in August, I don't know, I got my stamp on that was, you say it was June? Okay. It is what? Oh, thank you. No, you're right. Okay. Hold on. Yes, right. Okay. This should have been June 30th. The stamp in the file was July 30th. Okay. So June 30th. And she made, so has she paid rent twice to the landlord or just once? Just once. Okay.
I'm sorry, Judge, which case are we talking about, Smith?
Well, I'm talking about Smith. Okay, so let me ask this. Did you get a ledger on Smith?
Yes, Your Honor.
Okay, so I'm a little bit worried because her balance is up there. And I'm trying to figure out,
Your Honor,
yeah.
we are actually working on multiple fronts for multiple sources of assistance from Ms. Smith. She has suffered tremendous hardship over the last several months.
Got it. Okay. Those, I don't want to say this because this is a weird word now with funding and stuff. Are those prospects?
She's been provisionally approved for 4,000 and pending payment on the balance.
Okay.
Yeah, she's
So
also hoping
go ahead.
to be, she had employment lined up, which got sidetracked, and her employer is trying to find another position for her. So we're hopeful that she's also going to be employed sometime in the near future.
Okay, so the provisional approval of the 4, when you say that, she's got to get the other part done, which, according to their, is about another $3,000. Okay, let me ask this. I get the employment part, but how is that looking in terms of other sources right now?
Hopeful.
Okay.
And if you'd like for, Trish, I can give you more detail.
Yeah, in a minute, but let me just ask this. I'm just trying to get a framework. That 3,000 can somehow be closed, you think? You're working on that.
Yes, sure.
It's Ms. Woods, you okay? Ms. Smith, you okay? All right. Hey, pardon? It's okay. Don't apologize. You're good. Okay. Going back to Miss Wood's case, I think, with the receipts. Did you get a copy of those?
Yes, yeah.
Okay. And
Oh, they're souls. Oh, can you get the originals of the receipts? Yeah, I know that.
okay. Has she tried to trace on these at all? Or did
Try tracing.
I'm sorry, Tracy.
Did you want to?
yeah. Did you do a trace on these to try to find out if they've been cash?
I haven't traced them to money order.
Go ahead.
I haven't traced the money, haven't tried to do a
You
trace.
haven't tried to do that?
No, haven't.
Okay.
But I still have all 4 original money orders.
Oh,
I mean, the stubs.
the steps. Yeah.
So
the
that's
one
okay.
that you just
Yeah.
got a copy.
Got it. Okay.
But I haven't tried to track.
Money orders, I see why. No, okay, I got it. But you haven't tried to
No.
trace through this company to see?
No.
Got it.
Your Honor, out of the four money orders receipts, 3 of them are reflected in the ledgers. One of them is not reflected in the ledger, but it does not mean it's not somewhere in there, or it doesn't say who it's made out to. So it doesn't necessarily mean.
I signed everything at the front from the person who stamped them and put her initials on them.
Say that again.
I signed my money orders in front of the attendant at the front counter, and she stamped them with the Haverhill stamp, and she initialed the back of them to make sure I had all 4.
Got it.
Also, tell us which one is not reflected in the ledger.
Yes, the one that's ending in number 1336.
Yeah, we can assist Ms. Woods and help trying to trace that if that's what you prefer.
So how much was that one?
500.
That's a 500. Gotcha. So I'm only, bear with me because sometimes I've got to catch up, okay? So there are 4 things here, right? But only one of them is at
Missing.
3, right?
Yeah.
And that's the one ending in 36. So it's not looking at all 4, it's just got it. Mip, are all of these $500?
3 are 500. One is for the 58. So 1,500. 3 of them are 5. One of them is for the 58 because they can only do 500 at a time.
Right.
Yeah.
Okay. So
If I was allowed to pay online like everybody else could pay online with an e-check, I had to go and get my account unlocked because I could even pay from my banking account online because she had to unlock my account in order for me to even pay it online instead of me just going to get the money orders from the store and walking around with $1,500.
okay. So the portal's locked.
She unlocked it last month or when I went to her and said, why can't I pay online?
Okay. So
Now my portal is unlocked, but everything's going into escrow now.
right. And then that means you have to go to your bank and get cash so that you can pay it to. I gotcha. Okay. So I see a series of $500 credits. And so it, see, golly, well. Yeah. These four that you gave me. You took those all in at once
Yes, sir.
because
I
that's
have
how
the
you
same date on them.
that's how you pay your rent.
Yes, and then the sequence numbers all kind of match, except for just one of them, but all the last numbers match in sequence. Except one. I think one is like off by one number.
They're all.
Well, I see.
That's the last digits of them. They follow in like numerical order.
5, 6, 7, 8, but the next number may not be
Yes.
sequential. So you can't look at the last three. It's not that way.
Yeah, so the very last.
The last digit.
Yes, sir.
Gotcha. Okay. So is there a way? I mean, because I'll just tell you what my gut's telling me. My gut's telling me that it's not that she didn't pay. Somebody's missing the receipt of it. I mean, that's what my gut's telling me because she goes and gets 4 money orders every time to pay her rent. And I find it a little bit difficult to believe that she then took one of those and didn't give it to the lady. Quite frankly, I had the portal, but we wouldn't even have it.
Portal is closed, obviously, Judge, because it's in litigation, so that is why that's the
It was closed before the.
Hold on. What sense does that make?
That's it's not uncommon for the landlord for them to lock the portals once it's in court until it's resolved.
Why in the blue blazes would you do that?
I am, Judge, that's
Blue blazes is a legal term.
But if I may speak, at the time, a lot of the residents, there was a transition of systems, so that's why I opened up the portal. It wasn't that we went in and maliciously blocked the portal. There's a transfer of a new system we're going to, and a lot of people they got locked out. So we had to reopen the portal for people, but it wasn't anything that we deliberately did. But it does get locked out if you have an NSF or insufficient funds for in the middle of legal. That's when the accounting department, the corporate will lock it out. But hers, I don't show, was locked out.
I was locked out because you opened it. I sat in your office and you opened it while you were sitting there.
But that's what I'm saying. It wasn't locked.
But it wasn't locked. I just wanted to make sure, ma'am, I was just trying to figure out why were you locked out? And it sounds to me like it's a systems issue as opposed to a policy issue, just locking you out. That's what I'm.
I forget the manager's name. She said that corporate locks the accounts in litigation. Portals in litigation.
no,
that's what I
she,
heard.
she did say that. That's corporate. That's has nothing to do with my.
Why would they do that?
I don't know, Judge.
That makes I almost had a bad word. That makes no sense. Especially, I could see it if it were a termination case, maybe I could see that. But on a non-payment of rent case, why are we making it hard for people to pay? I don't get it.
I can defer to my client. She knows.
Just the system does not allow a partial payment, Your Honor.
Well, which is also stupid, but I get that. That happens with,
which is why I took the initiative to open it up to allow the partial to make it easier for the resident.
why aren't they just allowing the partial payments? People don't get a big check all at once. All that money doesn't go into their account all at once. So even if you tack on a late fee, but she can pay through the portal when she has it, right? It just doesn't make any sense. But it's unlocked for you now, right? You can make partial payments.
I put $3,200 in escrow, which is July's,
Right.
August rent. So that's it.
But you don't, okay.
So
And that's fair. You don't know whether it works because you've been paying to the court.
because I've been paying to the court. Yes, sir.
Got it.
I knew it, but I did go in and piggyback to make sure it was able to take my card, even though it was a $48 convenience fee to pay with my bank card. I can still go in and see that I was allowed to put my card in.
So they charge you $48?
Your Honor, I've instructed every resident to link your e-checking, which is only $3.90.
Got it. Right.
Right, it's going to cost you an offensive amount of stuff.
Yeah, I got you. Do you understand that, ma'am? That's not uncommon.
I wasn't unable to pay with the e-check even before we had our court. That's when I got it unlocked. But by the time I got it unlocked, I already had paid rent with the money orders.
All right. All right. This one's gonna. So if I take all the money that's in escrow, she's gonna owe
$1,222, but that does not
$1,222.
it does not include the $500. If that is located, obviously it would have.
I think she paid it. I'm gonna be honest with you. I think something. My gut is telling me something happened on your end. And I don't say that many times at all in cases involving money orders. But she gets 4 money orders and goes down and pays it.
I understand that, Judge. However, again, this is news to us. So this could have been easily reconciled outside of courts. We would have an answer for you now, but we don't, because now we have to go back and trace it. Both sides can trace this money order. And if she needs to be credited that $500, my client will credit her that $500, which would leave her with a $722 bill.
I tried to reconcile the first amount and no one would talk to me about the first amount that you said that I owed. And that's why we're here right now. And things are accruing the way they are accruing because no one would sit down and explain to me where the first amount of money came from when I asked them to. I kept getting dismissed.
Your Honor.
Ms. Woods, I hear you. Okay. And Ms. Woods, I'm not dismissing you. All right. That will never happen here. You understand me? So I get that. And you're right. People, you're trying to just do your business and people need to respect that and they need to talk to you. I hear you. How was, and I guess I'll ask counsel, how was, if she were to get the credit for the 500, how the 722?
Well, Your Honor, we think that they should also waive the late fees and the other charges, the $48 charge, because it was impossible for her to pay otherwise.
Well, it's not in the $48 convenience fees, a weird thing. I don't know what I quite do with that because it's not something where that's not an uncommon thing in the system, which is why she's saying link your e-check. And I don't know, I'm not even sure why there shouldn't be a fee on the e-check. Because they're going right.
It's being wired directly to their.
Yeah. Whereas I get it's crazy that it's $48, but I get it. I get that.
In Your Honor, that wouldn't have brought her to a zero balance. So
What would have brought her to a zero?
they were asking to waive late fees and so on and so forth. The late fees automatically accrue unless there's a zero balance on the account. There was no zero balance on the account. Even if we were to credit that $500, it wouldn't have been a zero balance. She still would have had a balance. And so those late fees are appropriate.
Well,
Your Honor, I have never been told that there was a missing money order. I do not dispute that that could be the case, but this is the first I'm hearing of that.
I know.
It could be they didn't put the right unit number. It's easily.
The right one?
It could have been the wrong unit on this money order. I was never told that.
Gotcha. I gotcha. No.
This is the first I've heard of this.
No, I thank you. And I appreciate that. I get.
Residents. But I wasn't told this till today.
Yeah. And no, I get it. I'm not saying that you wouldn't have done something. It sounds to me like when they come talk to you, they're hurt. I don't think what she was saying was really necessarily directed at you. Something tells me, because you're the one that got the portal unlocked. How much are late fees for you guys? That
50, 50.
So what would be the total amount of late fees that you're looking at?
I see 4-5 months at $250.
200 or 250?
255 months.
Got it.
I'm sorry, Judge. I'm going to have to object to any waiver of any late fees because of the fact that, again, the last time she was at a zero balance was in March of 2020.
Okay, I get you object.
My client is within the right to collect pursuant to anything that's within the lease, Your Honor. And so
You want me to go through an analysis regarding your late fee, because your late fees have to be accrued to your client efforts in attempting to try to collect rent.
right.
If I were to find, and I'm going to tell you, you can talk to the people at McKinley because I went through it. If you want me to order that, I will. It will be a nightmare for you to get the information to me that you want. I just give you that warning, counsel.
I guess so respectfully, Your Honor, the court is getting frustrated because
I'm not frustrated.
again, Your Honor.
Trust me, if I were frustrated, everybody would know and run. I am not frustrated.
So I believe that this case could have been resolved outside of the court's, without the court's intervention. And
Well, I'm here now.
we can still do that, Your Honor.
Okay,
If they're amenable to a resolution.
everybody needs to just stop talking. Because all I'm trying to do for right now with Ms. Woods is this. And I'm making my thoughts rather clear. I think she paid the 500. I think the 500 is just not, it's missing somewhere. It may have got, I don't think anybody tried to do anything intentional. I'm not saying that. But the way she would pay her rent, in my experience, somebody doesn't show up with 4 money orders and they keep one, right? That doesn't happen. And then keep the one that sequentially would be in the middle of the other two. None of that makes any sense to me. Yes.
Correct.
Yeah, I just, so it's, no, I get it. I get it.
Going to find around the same time, which would have been a $500 difference in her balance, which at that time, if it were received and applied correctly, it would have been, she would have still had a remaining balance of $462 if that $500 was applied.
Okay. Here's the deal. All I'm trying to do, Ms. Woods just wants to get to 0. Right, Ms. Woods?
Yes, Your Honor.
And in that way, she can figure out how to go on. Now that the portal's open, she can figure out all of that. She can get her rent paid. We don't run into the money issue. So all I was trying to get to was that she's at 720. If the 500 comes off, she's at 722. Then there was a indication regarding late fees, right? So if I just momentarily say she's at 722, and let's say I just take 200 of the late fees. Say right now, I'm not going to worry about them. Then I'd have to ask you, could you come up with $522? Or let me say, when could you? Better way.
2 weeks will suffice.
Pardon?
2 weeks will suffice. 14 days. If I can get 14 days, I can come up.
Pardon?
14 days.
Could you explain to me again how you come up with 522?
Because what I did, she's at 12, they gave me a number 1222. If I say I take the 500 off, right? Because I think she paid it, we just have to figure that out. Then I'm at 722.
Is that court costs and court fees?
Hold on, just a second. So then I'm at 722. Then I said, okay, there's $250 in disputed late fees. At some point we'll have to figure that out. But if I take 200 of that, and I just take 200 of that, I came to 522. And then I asked Ms. Woods, how long would it take you to do that? And she told me 14 days. It's funny. It's funny with all of these lawyers in here. The only one that was following me was Ms. Woods. Go ahead. What?
I just wanted to note, counsel just stated that if the $500 had been credited, her balance would have been 462. That would have been early June.
Early June. Okay.
462 in early June. And then I see in July, they charged her the $568 plus a $50 late fee. That $568 went into escrow. In August, they charged her $568. And this ledger says $40 in August late fees. That was put into escrow.
$1568.
So
Plus 40 in August. And so just from this ledger, it seemed to me that her balance is more like 462.
for what?
462.
We're right. And actually, had I taken the whole 250 that you disputed, I think we're at the same number.
I think it would have been even less because that,
No, so when you said you disputed 250, I just rounded to 200 to see where she was in terms of funds.
So even with
I didn't take the 250 off. If I take the 250 off, I'm at 722 minus 50.
that,
No, 722 minus 250. Hang on a second before you say anything. 672? No, you can't get
470,
472. What'd you say?
472.
470.
Which is, we're $10 difference.
Yeah.
That's what I'm saying. Had I taken the whole 250 that you're disputing, we'd be talking the same number. Basically.
Yeah, I don't know where council's 1222 number comes from, but we are,
Balance. That's the balance that she owes less escrow. That's where we started from. That's where the 1222 comes in. And then the 500 is, then you take off 500 of the money order. And then you got $250 of disputed late fees. Part of those late fees I may be able to solve right now. Did you charge her late fees for July and August?
yes.
yes. And
That's the $50. Those come off. She paid her money into escrow. There's no late fee.
I'm wondering, I mean, we might be looking at different ledgers because the final balance on this one that we just got from council is 4188. And when I subtract, I believe it's 136 in escrow, I get 1052.
That's before the attorney fee.
And we don't believe there should be attorney's fees.
Of course.
No, I know. I hear you. I get all of that. And folks, somebody's going to have to move on the numbers if it's going to get resolved. Ms. Wood's case is so close.
John, we agree, but we just want to say that you can rule today that you're denying our motion.
Or I can not rule at all.
But if
Today.
if you render a judgment, then you've denied our motion.
If I do what?
If you render a judgment, then you've denied our motion.
No, that's not true. That's what you would like to think, but that's not true.
We've moved for summary disposition. We don't have a ruling.
You're right.
And so you can't proceed to judgment unless you've denied that motion.
Have I said I'm issuing a judgment?
Are you?
Oh, when I'm issuing a judgment, you'll know.
Okay.
I'm just trying to figure out how to get her to zero.
And we know that we're close, Your Honor.
And here's what I'm saying. By default, the case gets dismissed, right? Frankly, with another payment, without a judgment. Because she would have zeroed. That's what I'm saying. And then Miss Woods can just go on and not have to talk to me,
And absolutely, if that's what she prefers to do, she's our client. We will accede to her wishes.
I mean, but you understand what I'm saying, right? So,
I understand what you're saying. My only thing was when I originally was told that I was owed the 352 and I asked her where did it come from. No one explained to me where it came from. But when I pulled out my security deposit payment program, 352 was the last part paid for my security deposit. The exact amount was what they told me I owed. They transferred from my rental account all my money over to my security deposit, which made me pay over $250 for a security deposit that was only supposed to be $2,350. That's why you wanted to see the case again, because when I told you that I didn't believe that I owed that money, it was like, okay, well, we need to see the case again so I can check.
I remember.
Yeah.
I can speak on that, Your Honor. And I took over Haverhill in April.
Lucky.
Yes.
Yeah, go ahead.
My observation was when they moved in, a lot of the residents weren't understanding. When they paid their monies, it sat on the resident side. It was their deposit with their intentions of having it be that. So when they would look at their ledger, they would think they had a credit. Once the accountant moved it over to deposit, that's when you would start to see then the negative pop up on that. So that's the first thing I saw. The other thing that I can honestly say, because I've experienced it, when I'm being cursed out, staff is instructed not to speak to anyone. I've been cursed out despite my motives to try to resolve with Ms. Woods. I've been cursed out. At that point, we disengaged, Your Honor. We're just not going to stand there and be there.
I have never cursed you out. Yes, I have became angry, but please do not stand here and say that I have cursed you out, because you would have called the police on me and had me escorted out of there if I was to cuss you out. You would have not just allowed me just to cuss you out freely and just walk away.
I should just cuss everybody out here. Thank you. Yeah, I'm sorry.
Despite the effort that I tried to resolve, sometimes we don't engage because of.
No, I get it. I understand all of that. I think folks, you just have to realize from my standpoint, week after week after week, I see folks that are so far behind, it's hopeless. And ultimately, they're at some point. I'm looking at Ms. Wood's case and I'm just, maybe I get happy because it's just not that far off and she can be at zero and everything can be okay for her. That's what I'm saying. And I don't, the months outside of the last 2 months, the months for the late fees are what months, Miss Eakley?
June, July, August.
April, May, June.
August.
April, May, June. And that's when you paid with money orders, ma'am? I'll tell you what. Somebody needs to find that 500. Here's what I'm going to suggest to the parties just as a framework to try to resolve this. I'm going to adjourn any ruling on this matter to just give me a Friday.
Oh, you want Friday?
Well, when's my next Tuesday?
August 25th.
Oh, all right. I'm adjourning any ruling on this case to August 25th. Okay. That's a Tuesday. I am inclined to, and I'm doing this just as a framework for the parties, I am inclined not to waive all late fees because she was bringing everything down there. And that in and of itself is a hassle, right? I'm inclined to believe, although you have to find it, that the $500 was paid. I'm inclined to split any costs that would be associated. Right down the middle, 50%, one way or another way. I think at that point, if you come up with a number from that, I think from what Ms. Woods told me, 14 days from now, she could have that paid and deed done. So your case, ma'am, I'm going to adjourn out to the 25th. Let your attorneys work with the other side. They kind of got my framework of whatever. And that's it. We can just be done.
Okay.
Fair enough.
Thank you. Thank you.
Thank you. On. Come on, bro. All right. Now, your case is a little bit more. You said you were on, that you had the provisional 4,000. Is that through Hawk or is that through?
The emergency housing fund.
Got it. What are the prospects of this, of the gap with the 3,000 being closed?
Waiting for responses on two sources and hopeful, but if for any reason the funding is not available, we believe they would assist her in relocating.
Okay.
With time. I mean, she has to put in applications, etc. So
Ms. Smith? You gave up hope there for a minute, didn't you? When you heard that, right? So let me ask you this. Why are you giving up hope?
It's like, it's giving out. I'm scared. They just been trying to transfer departments at my hospital because I had a cardiac episode and they fired me from that department. And so I'm trying to work with HR to get into another one. I'm not well. And I have a disabled daughter that I'm trying to protect. And this is the safest place I've ever been. I don't want to lose this home.
All right.
I care about this place so much. And I'm trying everything I can. I don't have parents or anything. I'm alone. And I want to pay them. I want to pay my bills and I want them off.
I know you do.
I feel like I'm dying. And I am in therapy, but it only does so much. It does not pay my bills.
Okay. All right, Ms. Smith, a couple things. You've got a lot going on. Sometimes one always has to look at, you kind of have to put things in order, right? Because we all have our lives and we can't deal with everything that's coming at us.
Very overwhelmed.
Huh? I know. And I can tell. And thank you for sharing all of that with me because I didn't know. Okay. Let's try to do this. Let's try to take one step at a time. Because we're trying to grab everything, right?
Yeah.
And that's where it all kind of gets overwhelming. Right?
So it's a bulk line, yeah. It's
What do you say?
Fix everything at once. I'm learning to not do that.
I'm the same way, and I had to kind of back up, right? So, what I'm hearing in this case is there's 4,000 that may be out there. We're trying to figure out the 3,000. It gets scary, and I asked the question, and counsel was answering me. It gets scary when all of a sudden, if that falls through, then we got to do X. But we don't know whether we have to do X, right? So at this point, we're not going to worry about it. Okay? And what I'm inclined to do, would the time work to try to figure, will you be the 25th? Yeah, would you be able to have an answer on that other piece, you think, by then, or? Hmm?
Oh, this has been human for a long time.
And I'm going to adjourn this one out to the 25th also.
Yeah. Are we looking at morning or afternoon?
That is morning. Okay. And Miss Smith? You got a lot on your mind. All right, listen. Okay. Regarding this issue, and this is the great thing about me and me. Okay. What'd you say? Well, thank you. But I want to tell you this, and it's true. I want you to worry about you got good lawyers here. I want you to worry about the other stuff you've got going on. Work, your job, your health, your daughter. I want you to worry about that. Okay? With regard to the case, they got you on that. And the other thing is, plain and simple, nothing happens until I say it does. So you're not going anywhere right now. Okay? So I don't want you worrying about that. Okay? All right. And I'll adjourn it out to that date. We'll see on the 25th. We'll get a better handle on the funding part of it. And
I won't give up. Thank you.
what?
Thank you.
Don't you dare give up. Because then I got to go out, got to get Alan, we got to go out, we got to find you and everything. And we got to have that whole conversation. We don't want to do that. Okay? You're welcome. All right. We'll see you guys in a couple of weeks.
Thank you. Thank you, God. Sorry, the money orders that were provided, can we see the back of one of them, just so she can go back to the office, Tracy?
Did she leave?
No, she had to go.
Oh, okay. She had to go to work. All right. Yeah. Take care of yourself, okay? You're welcome. All right. This is what this one.
What we're gonna say. Okay. You just have the one with 2 left, but I have not seen Anderson's counsel yet. I don't know if he's here.
Where is it?
Anderson, is your attorney here?
Yeah.
He's on the way? Okay. Court is standing in recess.
All right.